Welcome to Do It for the Case Law on Wednesday, August 19th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today we are covering 53 federal appellate cases across 8 circuits. Our legal team will break down developments in criminal justice including drug trafficking and firearms offenses, civil rights matters ranging from employment discrimination to voting rights and Section 1983 claims, Supreme Court and constitutional law issues including habeas corpus petitions, business and labor disputes involving securities and contracts, and immigration appeals alongside administrative agency reviews. For the latest updates on federal appellate opinions, subscribe or follow us on your preferred platform. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. We have 14 cases today from the 11th, 4th, 6th, 8th, and 9th circuits covering drug trafficking, firearms, fraud, and violent crimes. The disposition roll-up shows 11 affirmances, 2 dismissals, and 1 dismissal following an Anders review. Starting with the 11th Circuit, the court granted appointed counsel's motion to withdraw Jason Hazel's case after an independent review found no arguable issues of merit, affirming the conviction while noting that ineffective assistance claims must be raised via Section 2255 rather than on direct appeal. In a high-stakes fentanyl distribution case resulting in death, Joel David Fonseca Flores was affirmed for conspiracy to distribute and possess with intent to distribute the specific drug that caused Natasha Koch's death, with the court finding reasonable inferences from circumstantial evidence supported the jury's verdict. Kenneth McReynolds had his appeal dismissed because the district court's inquiry during the plea colloquy confirmed he knowingly waived his right to appeal and the alleged sentencing error did not constitute a miscarriage of justice. Wayne Lamar Davis faced an affirmation for possession of ammunition as a convicted felon, with the court holding that recent Supreme Court decisions did not abrogate its prior precedent upholding the constitutionality of the felon in possession statute as applied to felons. Alan Pendergrass was affirmed on his 30-month sentence for mail fraud and identity theft, where the court held that home detention does not satisfy the statutory mandatory minimum sentence when probation is prohibited. William Jack Filing's 180-month sentence was upheld after the court found no clear error in the district court's general finding of perjury to support an obstruction of justice enhancement. Moving to the 4th Circuit, Tress Avery Davis was affirmed for fentanyl distribution following a guilty plea, with the court rejecting his claim that officers promised leniency to make his confession involuntary. Alan DeSoma Jr. received an affirmation for life sentences related to sexual activity with fictitious minors as the sting operation did not rise to outrageous government conduct and no entrapment instruction was required. Jelani Jones's supervised release revocation sentence of 10 months in prison followed by 26 months of supervised release was affirmed, with the court finding the district court adequately explained its reasoning based on statutory factors and the defendant's struggles. In the 6th Circuit, Frank Clay Jr.'s 151-month sentence for felon in possession was affirmed, where the court upheld enhancements for reckless endangerment and firearm use during a felony involving cocaine distribution. Shifting to the 8th Circuit, Michael Bond's appeal was dismissed following an Anders review after the court found his plea agreement waiver covered the claim of substantive unreasonableness and no other non-frivolous issues existed. Jajuan Jarman's sentence for a drug offense was affirmed, with the court ruling that trading a firearm for a canceled drug debt provided a sufficient basis for the possession enhancement. Finally, in the 9th Circuit, James Vernon Day Jr. was affirmed for felon in possession and unregistered firearm charges, as the search warrants were sufficiently particular despite describing the property by total address rather than the specific outbuilding mailing address. Back to you, David.
Thanks, James. Let's turn to Aisha covering civil rights.
Thanks, David. 8 cases today across 5 circuits. The disposition roll-up 6 affirmed 1 split outcome with a reversal and remand, and 1 split outcome with a partial affirmation and partial reversal. Leading with the movement cases over in the 8th Circuit, Mary Holmes and others challenged state policies regarding the Supplemental Nutritional Assistance Program and due process rights. The court affirmed the lower court's decision on their federal due process and disability accommodation claims, but reversed on the SNAP Act claims and vacated a permanent injunction. The panel found that the advocacy group lacked standing because its injury was not cognizable, though the individual plaintiffs retained standing for their other claims. Moving to the 9th Circuit, Dr. Ding versus Structure Therapeutics involved the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. The court affirmed the denial of a motion to compel arbitration, ruling that the plaintiff could proceed in federal court because she only discovered evidence of sex-based mistreatment after arbitration had begun. In the 11th Circuit, Chase Peden versus Conway presented a split outcome on his employment claims. The court affirmed summary judgment on procedural due process and defamation claims, but vacated the ruling on the equal protection claim, remanding with instructions to dismiss that specific claim for lack of standing because he failed to exhaust state administrative remedies. Also in the 11th Circuit, Nicholas Ewing versus Sheriff Hardy was affirmed regarding the use of a canine dog.
The court held the deputy's actions were objectively reasonable given the suspect's history and outstanding warrants for serious felonies.
Over in the 10th Circuit, the estate of Wilford Deweese versus Hancock was affirmed on qualified immunity grounds. The court ruled that the plaintiff failed to show the officers violated clearly established law, so it did not reach whether the force used actually breached the Fourth Amendment. In the First Circuit, Five Star General Store versus American Express was affirmed. The court held that American Express waived its right to compel arbitration by refusing to pay administrative filing fees, constituting litigation-related activity inconsistent with an intent to arbitrate. Finally, in the Seventh Circuit, the Public Interest Legal Foundation versus Wisconsin Elections Commission was affirmed on dismissal. The court rejected arguments that the National Voter Registration Act's exemptions violated state sovereignty or congruence and proportionality principles. Back to you, David.
Thanks, Aisha. Let's turn to Michael, covering constitutional law.
Thanks, David. 3 cases on the docket today. 1 dismissal, 1 affirmation, and 1 split outcome. We begin with a split decision in the Seventh Circuit. The court affirmed summary judgment for 2 officers but vacated qualified immunity for Officer Price, remanding the case regarding an inmate's Eighth Amendment rights during transport. The court found that failing to intervene when an inmate was subjected to reckless driving and refused seatbelt restraints could constitute deliberate indifference. Moving to the Sixth Circuit, the court affirmed a 292-month sentence for enticing a minor. The panel held that 2 separate sexual assaults were relevant conduct during a continuing offense, triggering a higher base offense level for aggravated sexual abuse. Finally, over in the 11th Circuit, the court dismissed an appeal challenging a 175-month sentence for Hobbs Act robbery based on a valid waiver in the plea agreement. Back to you, David.
Thanks, Michael. Now for business and civil law, Maria has the rundown.
Thanks, David. 18 cases on the docket today across 8 circuits. The disposition mix includes 11 affirmances, 1 dismissal, 2 denials, 1 reversal remand, 2 remands via certification, and 3 immigration-related outcomes. Starting with the First Circuit, we have a reversal and an affirmation in securities matters. In the appeal by Jeremiah Nichols against Veolia Water Contract Operations USA, the court reversed summary judgment for the defendant and remanded the case. The ruling turned on recent answers from the Massachusetts Supreme Judicial Court clarifying the Prevailing Wage Act and the special act governing the Springfield Water and Sewer Commission contract. The SJC defined improvements as valuable additions enhancing value or utility, rejecting the district court's categorical exclusion of the plaintiff's work. Conversely, in the securities litigation involving Apellis Pharmaceuticals, the First Circuit affirmed the dismissal of a putative class action under Section 10 of the Securities Exchange Act of 1934. The court held that statements regarding clinical trial results were not actionable half-truths because no critical qualifying information was omitted. Also in the First Circuit, the court affirmed disgorgement liability against relief defendant Raymond Gastower for approximately $3.3 million plus interest, ruling he forfeited all arguments by abandoning the litigation on remand. Moving to the 11th Circuit, we see 1 dismissal and 2 affirmances involving banking and insurance disputes.
The court dismissed Aubrey Bibbs's appeal against American Express for lack of jurisdiction, finding the district court's order denying reconsideration was not final under Federal Statute 12,991. In Sam Lewis v. J.P. Morgan Chase Bank, the court affirmed dismissal for failure to state a claim, holding that a breach of the implied covenant of good faith cannot exist absent a breach of an express contract term. The 11th Circuit also affirmed summary judgment for Century Surety Company in a dispute with Rockwell Property, ruling that a fire within one building of a 5-building resort complex did not trigger civil authority coverage because all buildings were part of the described premises. Over in the 4th Circuit, there are 3 affirmances and 2 immigration-related outcomes. The court affirmed dismissal of Nancy Levine's negligence action against Yankee Candle for failure to timely effect service under Maryland state law. In a wrongful death case involving Brian O'Connor against Fairfax Taxi, the court affirmed dismissal, applying diversity jurisdiction based on the decedent's South Korean citizenship rather than the administrator's status. George Stanley Branham's petition for a certificate of appealability was denied due to insufficient showing of constitutional error in his habeas claims. In 2 immigration cases, Kemar Rogello White's petition was granted and remanded regarding cancellation of removal eligibility after a recent Fourth Circuit decision clarified that a Virginia firearm conviction is not categorically a crime of violence. Similarly, Maria Laura Serrano de Melendez's petition was granted and the Board of Immigration Appeals order vacated because the agency failed to provide a reasoned explanation for denying asylum and withholding of removal. The Sixth Circuit issued 1 affirmation involving ERISA preemption. Medical providers' state law claims against an employer were dismissed as expressly preempted by the Employee Retirement Income Security Act of 1974. In the Seventh Circuit, 2 cases were remanded via certification of questions to the Indiana Supreme Court. Both matters involve mortgage guarantees and the enforceability of waivers against Indiana's one-action statute, which prohibits simultaneous foreclosure and suits on guarantees. The court found state law ambiguous on these points and certified dispositive questions for resolution. Finally, the Eighth Circuit affirmed approval of a nationwide antitrust class settlement involving the National Association of Realtors and Buyer Broker Commissions, awarding $333 million in attorney's fees. In the Ninth Circuit, there were 4 rulings, 2 affirmances in bankruptcy matters, 1 affirmation in arbitration, and 1 split outcome in a separate context not listed here but covered by the count. The court affirmed denial of summary judgment in Homesite Holdings LLC's nuisance claim, finding factual disputes regarding the statute of limitations. In Teleport Mobility v. Savula, the Ninth Circuit affirmed confirmation of an arbitration award, rejecting challenges to the arbitrator's denial of a continuance as failing to meet the manifest disregard standard. That concludes today's business and civil coverage. Back to you, David.
Thanks, Maria. Now for immigration and government news, I turn to Raj.
Thanks, David. 10 cases on my docket today. The disposition roll-up is 3 reversals or remands, 4 dismissals, 2 denials, and 1 affirmation. Starting with the movements, the Ninth Circuit reversed and remanded a district court's denial of a shareholder class action against PennyMac Mortgage Investment Trust, holding that the bank's fixed dividend rate following Labor's discontinuation qualified as a valid benchmark replacement under federal statute. The panel also reversed a Social Security disability denial, finding the administrative law judge failed to provide clear reasons for rejecting testimony about the claimant's need to elevate his legs and relied on insufficient evidence for the residual functional capacity finding. Additionally, the Ninth Circuit reversed in part and remanded a False Claims Act qui tam action against Regeneron Pharmaceuticals, ruling that the public disclosure bar did not apply because transactional data regarding payments to physicians lacked the specific details necessary to put the government on notice of the alleged fraud. On the dismissal side, the Ninth Circuit dismissed a petition for lack of jurisdiction where the petitioner failed to clearly challenge the legal basis underlying a discretionary denial of cancellation of removal, and it granted a separate motion to reopen regarding a motion to reopen cancellation proceedings, finding the Board of Immigration Appeals committed legal error by ruling that health evidence was irrelevant. The court also dismissed a Convention Against Torture petition, upholding the agency's aggregate risk determination that the petitioner faced no substantial likelihood of torture in El Salvador due to a lack of specific gang membership ties. In the Sixth Circuit, the panel denied a motion to reopen removal proceedings because the petitioner failed to establish a reasonable likelihood of visa availability for his pending Violence Against Women Act self-petition. Moving to the 11th Circuit, the court dismissed a petition challenging a reinstatement order because the petitioner explicitly limited her review to the reasonable fear determination and did not challenge the underlying removal order. The panel also denied a motion to reopen removal proceedings where the petitioners failed to demonstrate reasonable diligence or extraordinary circumstances to overcome the 90-day filing deadline. Finally, the 11th Circuit affirmed a Social Security disability denial, finding substantial evidence supported the Commissioner's adverse credibility determination regarding inconsistent medical records and testimony about medication side effects. Back to you, David.
That wraps today's broadcast of Do It for the Case Law for Wednesday, August 19th, 2026. A huge thank you to our reporting team, James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel. Today's docket saw 34 affirmances, 10 dismissals, and 9 other dispositions. The most significant outcomes came from the reversals, vacated decisions, and remands that reshaped legal standards across multiple circuits. Several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe to the show and follow us for daily updates.